Good morning, everybody, and welcome to another episode of the Raad Life. Today, I have a good friend of mine and a very well-respected attorney in Orange County, my friend Brendan Ford, who I've asked to join because I want to talk about what he's doing now. And it's something that he kind of kicked off in the midst of the pandemic. He is providing an alternative form of legal service, which is basically mediation. And there's a whole reason, a multitude of reasons why this actually makes a lot of sense, especially now. But I wanted him on to basically talk about the history of this and how he found himself doing it. He provides that service through his law firm. And so I want to bring him on and want to talk to him about that and also what he's seeing maybe going on right now, because these are very much new times, new territories. Hey, Brandon, how are you?
Hey, I'm great. How are you, Rod?
Good morning. I appreciate you joining me, my friend. I was just saying that, you kind of in the midst of this pandemic took your legal experience and you added a service, an offering that you found maybe was very timely, but it also is something that's been around, but it seems like it's coming into its own more right now. So if you wouldn't mind, take a minute, introduce yourself to whoever's listening to the show, and give them a little background about what you do and how long you've been doing it and why this sort of new direction, if you will.
Sure. So first of all, Rod, thank you very much for having me on this show. I appreciate being here.
My pleasure.
So my name is Brendan, and I'm an 18-year litigator. I have been in court litigating product liability cases, labor and employment cases, business disputes. I was a partner at several large national and international firms before starting my own shop about 5 years ago. And I've been a trial lawyer, and I've been dealing with the litigation end for a long time. What happened, as we all know, life changed both in the law and outside the law in the middle of March of this year.
Pretty much.
Pardon me?
I said pretty much for everything.
Pretty much for everything, and the law was no different for that. And so in the middle of March, the courts closed really for the first time in the history of Orange County. The Orange County and all the Southern California courts closed. And so from middle of March, all of March, April, and May, no one had access really to the courts with very, very rare exceptions. So I'm a civil litigator, which means that I fight over money. I don't do criminal, I don't do family, I don't do probate, I do civil litigation. So with extraordinarily rare exceptions, civil litigation was stopped. Civil trials were stopped in San Diego, Orange County, and LA.
Was it gradual, Brenton, or was it like instantaneous?
It was more or less instantaneous. It was toward pretty much on March 17th, I think it was. Forgive me on the date, but it was on March they issued an order, and then as circumstances continued to deteriorate, they kept kicking the can 2 weeks at a time or so. So it's closed through April, now it's closed through May, now it's closed to the end of May. And courts finally started opening up again in June, but at a fraction of the capacity that they did pre-COVID. And so the issue was, to me, very clear. There's this massive backlog of cases that for 10 weeks we're not able to go through the process. And so then the question becomes, how do these cases get resolved? Because there's such a massive surplus of cases that it exceeds really the capacity of the court to resolve.
Which was already, the system was already strained to begin with, right?
Absolutely. I mean, anyone who's a lawyer in Orange County can tell you whenever you ask a judge about something about caseload, they talk about how many hundreds of cases each of the judges within the Orange County Superior Court has.
Yeah.
And so you took a system, to your point, which was already overwhelmed, and now you made the situation much, much worse.
Right.
So given the fact that we cannot try all of these cases, it is physically impossible for us to have trials for all of these cases. Mm-hmm. How do we resolve those cases? And so my thought was, let me help be part of the solution, because the problem was overwhelming and it was obvious. And so I added a mediation practice to my already existing.
Were you doing that? Like, did you, in the course of your long career, did you do that? Was it something that was sort of a rarity that you went down this path? How was it before? Because you were telling me before we got on the show that this is something that's been around. It's just that it seems over time it has evolved and it's taken on more of an important role, right?
Correct. So as a lawyer representing one of the parties to a lawsuit, I've participated in hundreds of mediations. The change now was for me to transition from my role as an advocate from one of the parties to a mediator who helps take both sides and bring them together to a solution that works.
Got it.
And so it works. It's an important thing because we have too many cases and we have to have a way to do it. And so basically, just to make sure that we're all talking about the same thing, mediation is a guided negotiation where the mediator serves as kind of a third party, right, and helps bring the two parties, the two litigants together to a resolution that works for everyone. And so why is mediation superior to litigation? And I say three things, and the third is the most important, but the first is it's very efficient. Typically a lawsuit, as you probably know, if a lawsuit gets filed, you're talking a year, 2 years before it gets there. Even under ideal circumstances, forget right. COVID. COVID has messed up the calendar. Second, on mediation, in contrast, can usually take a day. So that's a huge benefit. The second is that it is much, much less expensive. Litigation, and everyone will agree with this, has become much, much, much more expensive over the last 40 or 50 years, particularly given the advent of experts and how important experts are into almost every case. And for experts, you're going to be spending tens of thousands of dollars. And for big cases, you may be spending hundreds of thousands of dollars in costs that just become really cost prohibitive for people to get resolution and get through the door. And then the third part, which is the most important, at least to me, is that you get to control the outcome of the lawsuit. When you file a lawsuit in court, ultimately a judge or a jury is going to make a determination as to whether your case has merit.
Right. You're basically you're presenting your best case, and then it's in somebody else's hands. You don't really have a lot to do with the solution.
Exactly right. And so obviously that leads to people being very disappointed, the losing side. And no one can predict these things. I mean, any lawyer worth his salt, myself included, I've won cases that I thought I would lose. I've lost cases that I thought I would win. And pretty much any lawyer who tells you that they can predict the outcome of a lawsuit is either lying or hasn't litigated many cases. So it's a really a crapshoot. And it's
Brandon, I'm sorry to interrupt you. I want to just take a minute to put up your logo, the firm logo, and your website.
Oh, thank you.
Yeah, no, absolutely. Because I want to make sure that whoever's listening, if they want to go find out more as you're talking, that's it. It's right there. How long have you guys been in practice, you and Chris?
We have both been, so I graduated in 2002, so I've been practicing for 18 years, and Chris graduated in 2003, so he's been practicing 17 years.
Yeah, so that's I mean, you've seen your share of stuff.
Yes.
And I would say that, and maybe you can tackle this as well, but it seems to me that you're also subject, I mean, taking on mediation right now, it makes a lot of sense when you start thinking about the time, duration, and the cost, right?
Right.
But I just don't want to lose focus of this, because we are in a heightened case where people don't talk to one another. Like you need people to actually be willing to sit down and solve something, right? Right now, we seem to be a society that basically doesn't want to solve anything or come to agreement on anything. So does that play a role in this? I mean, are you or do you find that when push comes to shove, time and money basically wins out, because it's like, okay, I'm going to put my differences aside because this is good for me? Can you speak to that?
Sure. I mean, I believe strongly that mediation in general is a superior alternative to litigation. But to your point, I absolutely agree that in this COVID time, I believe that COVID has created an increased sense of pressure and stress in all aspects of life. Stress in the home, stress in the workplace, stress in our businesses, stress in, I mean, it's permeated every single aspect of our life.
Yeah.
And with pressure and stress comes conflict. And with conflict comes, you have these butting heads, and you have to find a way to resolve those butting heads in a safe and normal. We don't do duels anymore. We don't do those types of things. We have to find a way to in a healthy and civil manner resolve these disputes. And that's one of the reasons why, particularly in this day and time, given the increased conflict and the resultant increased amount of lawsuits that are sure to come down the pike, and we can talk more about that later,
sure, but
it's absolutely essential that we find as many different ways to resolve disputes as humanly possible. And so I believe that mediation is an excellent way, because you sometimes can get beyond the simple, I want money, I don't want to give you any, and kind of come and transcend that and find some kind of resolution that benefits both.
Well, I find it interesting because, you know, we talk about this all the time, but here's a perfect example maybe that plays out in a beneficial way. We always talk about that people now don't talk to one another, they talk at each other, right?
Right.
And so you can't have a mediation by talking at a person, because that's just going to basically fail.
Correct.
You actually have to come to the table and be willing to talk to the person, or maybe obviously maybe through you as a mediator, but
right.
you know, so it's funny because it's really interesting. You know, we're having kind of dualities. We got all these pressures and stresses, and I actually have a gentleman that was supposed to be on last week with me to talk specifically about this, right? The stresses that are happening right now because of this, and you have that going on, but you also have this sort of like divisiveness on some key issues that are being politicized and weaponized, right? Especially in an election year. And I think there's a part of me that thinks that come November, you know, after the election, a lot of the stuff is going to go away because a lot of the pontification is going to be kind of like there's no point to it. But that being said, I just want to take a moment to talk about mediation and sort of the process. So let's say somebody has conflict, right?
Right.
Do they need to go into mediation or know that they want to do mediation to begin with? Do they file and then they basically still have that option? Can you walk people through sort of the process?
Sure. That's a great question. I want to take one step back though,
Sure.
to address your point where you were saying people were talking at each other as opposed to each other.
One other.
Yeah. So one of the big changes in mediation and negotiation happened in the 80s when there was a book called Getting to Yes, and that was written by Roger Fisher and William Ury. I encourage everyone listening to read the book. It's a fantastic book. And it focused on, before that book came out, the focus was just how do we divide the pie? And basically one party starts at 0, one party starts at 100, and we just chop away till we get somewhere near 50.
Yep.
And that was a very unsatisfying way of negotiating disputes because it didn't get to the root issues that were causing the conflict. And so what Fisher and Ury talked about was, and it's elegant because of its simplicity, which is focus on the interests, not the positions. And what that means is, and the example that they give, which I love, is an example of an orange. And so two little boys want this one orange that's in the house. And the dad is trying to figure out how to divide it. Boy 1 wants it, boy 2 wants it, and he just wants to split the orange in half and give half to 1 and half to 2. Well, the mom read Getting to Yes, and so she said, why do you want the orange, son number 1? And son number 1 said, well, I want it because I want to have a glass of freshly squeezed orange juice. And they asked son number 2, why do you want the orange? And he said, well, because I want to use the peel to make a cake. And so by asking the interest, the mom, being smart, was able to fashion a resolution that gave the boy number 1 everything he wanted, the actual orange, and boy number 2 everything he wanted, which is the entire skin, and both got 100% of what they wanted, as opposed to the dad's problem or solution, which was neither side was going to be wholly happy.
So the dad's solution was, I'm cutting it in half, you guys sort it out.
Yes, exactly.
And to your point, each one of those, each one of the boys ended up with half satisfaction to what their interest was.
Exactly.
Right. Versus, right. And I'll just throw this in too. And then the pulp went into the garbage disposer and basically sanitized and freshened the garbage disposer.
Exactly. So both sides with the dad's solution were left half unhappy. Yeah. And so the mom's solution was infinitely better because by asking that, and that's obviously a simple example.
No, but the reason I even brought that up, Brendan, because I'm familiar with that book. I actually read it, and I got chastised at business school when I basically proposed that the pulp also had some value, and the teacher was basically like, "Don't distract us. We're talking about the skin and the juice, right?"
There you go.
But my point is that if you think outside the box, there may even be more benefits than the ones that are interests that are currently you're aware of or trying to achieve, and there may be an additional benefit that comes out of that process.
Exactly. So what ends up happening, and why that was such a revolutionary book and such a revolutionary concept, is because when you just do money, you often reach an impasse, and you say, well, I'm not taking a penny more than X, or I'm not offering a penny more than Y.
Right.
And what happens is you can't, if it's just on money, you can't bridge the gap. And so what finding the interest is and you find that the money is often a proxy for some other interest. So like in a medical malpractice case, a lot of times it'll be a question of the doctor didn't apologize for hurting my
Right.
son or hurting my child.
Right.
Or in a labor and employment case, a lot of times it's they want to raise, but really it's just, I don't feel like you appreciated me and my contributions to your company.
Right.
Or in a trust and estates case, you often have a situation where a lot of times you have the dad who had wife number 1 and adult children, and then wife number 2 and minor children, and then the dad dies. And you have a lot of stuff like dad never loved me, or he loved you more than them, or whatever. And really you're expressing that anger or that frustration or whatever the emotion is via money. But when you get to delve under that and get to those things, you can fashion things that make sense.
Well, I think that's understandable to a certain extent, because I think the way society is wired when it comes to evaluation of value,
Right.
is really at the bottom of this thing, right? I mean, we
Right.
evaluate value or associate value, and in certain countries differently as well. But culturally, in the West, we're to a great extent, we evaluate value as being represented by a dollar sign or by a monetary amount, right? And then I've been dealing with this because, again, interestingly enough, COVID has basically really challenged our definitions of status, our definitions of success, right? So
Our entire value system.
It's really because and I think this is interesting to bring up because of what you're talking about, because I think people are now evaluating things like by being sequestered at home by choice, by the way, right? As much as it's like, they're not letting us go out. Nobody's holding a gun to your head and saying stay at home, right? You're doing that by choice, out of fear, out of cautiousness, whatever it is. Well, we are evaluating value differently, and is success now being measured more in terms of fulfillment,
right,
than size of bank account?
Correct.
Right, because the way society is that you basically kill yourself for 50 years of work, and then basically then you go play golf for the rest of your life for another 20, 30 years. And we already knew before COVID that I can't play that much golf because I'm now living longer than my parents. And I don't want to be on the links for 30 years. I got another encore career maybe is a passion pursuit. So fulfillment is now, maybe for me at least, and what I'm trying to basically tell people is use the word fulfillment as a better measure of whether you are at a point or not that you can say you have a success.
Right.
It's the dollar amount in the bank. It's, to your point, this is where you have conflict, but some of these same basic elements are at play, and we are maybe in a paradigm shift where we're changing our thinking that makes this sort of more of a viable option.
Right. So I agree with you wholeheartedly. One of the other words that I've heard in addition to fulfillment is legacy. What is your value is what is your legacy to other people? And I'll give you I didn't mediate this case.
But hold on, don't go so fast. You said legacy, but it's actually the continuation of that paragraph that you just said that's really what gives it value. Your legacy to other people.
Correct. No, and without,
you can't have a legacy without that other people being part of that equation.
Agreed. No, a person on an island doesn't have a legacy. I agree with you. Yeah. But to that point, and just to give you an example as to how mediation can play into the legacy issue, there was a very well-known case where a boy or a young man, 16, 17 years old, had died tragically in a car accident because of a poor road design.
Mm-hmm.
And the city had a certain amount of money, and the parents were really upset. And the parents were upset because when you dig deep, they thought that they had really the perfect child. And by all accounts, he had great grades. He was just the sweetest kid in the world. He just everything that you could ever want. Successful, and he was a great athlete, and et cetera, et cetera. So he had this unbelievably bright future. Yeah. And the parents, getting to that underlying interest, what I'm talking about, the proxy for money was, you're not valuing how unbelievable our son was. And you took him away from us, and you need to pay. And I need something there. And there was a gap, and it couldn't be bridged because the parents were never going to go below a certain number. And the city, due to insurance issues, couldn't go above a certain number. So there was this gap. And so you think to yourself, well, how do we bridge this gap? And the way that they did it, and that whole outside the box thinking, is the city ended up renaming its local baseball stadium in honor of the guy who died.
The legacy.
The legacy. And they had a ceremony with his jersey, with his family, with a ribbon cutting, with a band, with the whole 9 yards, to show how much we honor him and all of his contributions and all of his legacy. And they were able to bridge that gap without a dollar more up or down. So that gap existed and never changed. But because people were thinking outside the box and thinking about what you're saying, which is not just what your bank account shows, but what is your legacy and what is your meaning and your level of fulfillment to society at large, they were able to fashion something that was able to bridge that gap and create resolution.
In this particular case too, I would think that the parents were looking for recognition.
Exactly.
For their child. They were looking
Yes.
for recognition of value that wasn't really monetizable.
Correct.
And so that basically made it palatable for them.
Exactly.
They felt, that their grief was being valued.
It wasn't in vain. Exactly.
Their loss was not in vain.
Right.
No, absolutely. That's a great example. And so why is it that people don't do this by nature? Do we have just a combative win? I need to win. I need you to lose. Like, what is it that basically?
I'm not sure. That's actually a great question. I really don't know the answer to that. Looping back to one of your earlier questions, which was just, when can this come up? This can come up at any time. So I encourage people, as soon as a dispute arises, to forget it whether a lawsuit has actually been filed. And I'll give you like 2 examples just off the top of my head that where that makes real sense.
Sure.
One is if you have a closely held partnership, whether it be any kind of LLC or a partnership or a medical practice or a law practice or anything like that. We don't need to, once the lawsuit gets filed, it's kind of like you broke Humpty Dumpty and you really can't put it back together again. And so before that happens, when the initial barbs and slings and arrows get thrown back and forth, where ultimately it ends up being where one person believes that the other person isn't doing enough.
Right.
That's when you get a mediator in there to like talk it out. So like, let's say, okay, you're upset about XYZ, you're upset about ABC. How can we get this so that we can continue to move forward together? That's critical.
So do you have to do that prior to filing a lawsuit? I mean, I'm just talking about the nuts and bolts here. Do I need to go to mediation or consider mediation before I file a lawsuit? If I filed a lawsuit, does that omit the opportunity to do mediation? Does it make it less likely that we are going to avoid certain things? That's what I'm trying to understand. Like for people that are finding conflict right now,
sure,
maybe one, they're thinking for whatever reason, the cost I can't afford. I don't know whether I have a job next month, whatever it is, right?
Sure.
Do I need to know and be aware that I need to probably consider mediation before I proceed with a lawsuit? Or
sure.
Can I take a situation where I am in a lawsuit, maybe I get the other person to consider that this is a viable option and go to mediation, or am I unable to?
No, the answer is both. So you don't, the only instance that I'm aware of where you have to have a mediation before you file a lawsuit is if there is a dispute over real estate between a broker and the person. So the California Association of Realtors has a mandatory mediation before you're allowed to file suit. But other than that, you don't have to file suit before. And I think it's advisable before things can kind of spiral.
So it's interesting that industry is the only industry that actually has that as a mandatory thing.
Correct.
Right?
That I'm aware of. So I've been on several of those. It's called CAR. So that the CAR mediations are frequent and they require it before doing so because they want to encourage, resolving these things.
I'm thinking this maybe should be something that's other industries. I mean, it would be smart from a cost impact, all this stuff. How are mediations and arbitrations different?
So in several respects, but a mediation it's voluntary and it's non-binding, which means if you don't get to a resolution, you can both go your separate ways and continue your lawsuit. An arbitration is basically, it replaces a judge and jury, where an arbitrator, sometimes it's one arbitrator, sometimes it can be as many as 3 arbitrators, will listen to the evidence in a formal setting, but less formal setting. It'll be like in a conference room, but you have witnesses, documents, kind of all that stuff. The rules of evidence usually apply. And then the arbitrators come to a decision. One of the challenges with arbitration is that it's binding, so you still have that thing where you cede control. So I believe that mediation is superior to litigation and arbitration because you control the outcome. but an arbitrator makes his or her decision, and ultimately your appellate rights are really, really limited. So once that call is made, it's basically done. A mediation is, it's a much more organic process where you try and find interests and common ground and bring two parties or more parties together.
So what you're saying is, if I would like to maybe go that extra mile and do a mediation, right?
Mhm.
And we do that, and then we come to some sort of conclusion, and then I change my mind and I don't want to accept it, I am under no obligation to basically do so? Or are there any binding components to mediation?
There are binding components to mediation. So once you, under California law, once you agree to the deal point, okay, we're going to settle for X dollars and we've agreed to these 5 key term points. We all sign, it's basically like an LOI. Essentially, it's a short form settlement agreement.
Yeah.
That's enforceable under California Code of Civil Procedure 664.6, which allows you then, once that's signed, if you say a day later and say, you know what, forget it, I'm out, I can go to court and say, no, Raad agreed to this,
and here it is.
and you're bound to that. So there are binding aspects to it once you have an agreement and once there are signatures.
How long
until that point?
Go ahead. Go finish your thought.
No, I was just going to say, but up until that point, until they proverbially shake hands and ink is on the contract, then there is no deal, and so people are free to walk away.
So you said when we first started that mediation could take a day, right?
Yes.
So I'm just going to ask you from your experience.
Sure.
I mean, how long has it been since you've added this as an offering through the firm?
Since the beginning of COVID.
Okay, so 3-4 months basically,
Yeah.
right? Okay. How many mediations have you been part of in that period of time?
A few.
Okay. Would you say that on average, the duration of time to resolution or to accepting in a binding way the results of a mediation have been what on average for you?
It really depends on the case. I'll tell you, the last one that I settled was a product liability case that took 4.5, 5 hours. So we got there, started at 9, finished about 1:30. But I have been involved in mediations where the parties are there 9, 10, 11 o'clock at night, and we started at 9. It depends on the nature of the dispute. I've been in cases where, one party wants $100 million and one party says 0. It's going to take an awful long time to.
So I guess what I'm asking is, have you had ones that have gone over days, weeks, or is it?
No, never weeks. The most that I've ever been involved in was 2 days. So
that's great. That's awesome. I mean, this is what I'm trying to get to. Is it's still very short?
And that was on a consumer class action case where the parties were tens of millions of dollars apart at the beginning, and so we basically reached an agreement on the first day. We reached an agreement. It was a long day, so we started at like 8:30 or 9. By about 10:30 or 11, we thought we had an agreement, and then unforeseen circumstances happened and blew up the deal. And so we had to have a second one to try and fix it, and we did in a second full day. And so it was very long, but that's the longest one I've ever been involved in, was 2 days.
No, that's great. It's still amazing. Yeah.
But most are done within one. Usually you start at 9. If you have a half day mediation, it goes till 1. If you have a full day, it goes till 5 or 6. Oftentimes it will go beyond that, because that's when, that's when you really start getting to the chaff or the whip.
So are there any conflicts that should not go through this, or is it pretty much anything? Can you think of anything at all?
No, not at least in civil. No, I can't. Honestly, criminal cases can.
Well, yeah, that's a difference.
Right, but no, family law cases have mediations all the time, and I don't do family law, but I have a number of friends that do it. It's a vastly superior way to avoid the heartache. Oftentimes there are children then involved. You have assets, and so being able to just have wife and husband in 2 separate rooms and do shuttle diplomacy to come out something where everyone wins is amazing. Probate cases always are good for mediation, where people are upset about the trust and about this and about that, and those are great cases. And civil cases are all, I think, well suited. In particular, we do a lot of business disputes, and one of the things about business disputes is that sometimes you have to continue a business relationship with someone that you're not happy with, whether it be a supplier, a customer, a key partner. I'm aware of a case where they wanted to sue someone who was the exclusive provider of the software that the bank needed in order. It was a bank versus a software company. And the software company was the exclusive provider of the software that the bank needed to bank. And so, those types of cases are obviously should go to mediation, because if you get to ugly litigation, now you're real business consequences.
Well, and you have to continue later potentially, or now the impact and the cost of not continuing is actually even more compounding.
Exactly. Or sometimes, labor employment too. You want to lower the temperature sometimes. Let's say it's a key employee or a key executive, and it would be a tremendous loss to the company if he or she left. Gosh, why not explore mediation to see if there's some kind of way to bridge whatever differences or whatever issues exist, and resolve them, so that you have this individual who's contributing so much to your company. Why not have him or her stay as opposed to leave and then likely sue you for something else? So
so because I don't want to end on this particular point, I want to just address it. So how do you guys get compensated? Because I really want to end on what's going on right now and what you've seen going on and what you see coming forward, because you and I talked about this, and what's coming forward is something we really should talk about. But how do you guys get compensated for the service?
It depends on the case, but typically the parties split the cost of the mediator. So most mediators have some do it hourly. I do it where I have a set fee for a half day and a set fee for a full day. And then that usually is either 4 hours. Half day is 4 hours of mediation with 1 hour of preparation time. And full day is 8 hours of mediation with 2 hours of preparation time. And there's a set fee for both of those. And
that's great. And is that set fee based on the magnitude of the mediation, or is it just pretty set?
It's pretty set.
It's sort of time based, but half a day, full day kind of.
Yeah, that's every mediator sets their own schedule and their own fee schedule. So it fluctuates. Some people will do it where it's pretty much based on the amount of issue, but more often it gets segregated based on the type of dispute. Like if you're having a multi-billion-dollar class action lawsuit with securities fraud or what have you, there's a handful of people. There are a handful of people that you're going to
skilled to do that, and
those guys are going to command tremendous rates, because they're providing them. If there's one guy who's notorious or famous who is in Hawaii and San Francisco, and he settled the Facebook dispute that was highlighted in the social network, and so obviously a thing of that magnitude is
going a price tag that went with it.
That has a price tag, which makes sense, and he's providing value and resolving billions of dollars in potential litigation. I think that
you're bringing value to the table. No, the reason I asked it is because in either case, whether it's like Facebook situation or not, for the parties involved, you go in knowing what you're looking at. Is what my point was, versus a dragged out, I'm not sure.
Oh, absolutely. Yeah. No, so there's cost certainty. So I send a memo out to the lawyers, and here's my fee, here's this. It's absolutely clear, how much time you're going to have of mine, what the cost is going to be, what I'm going to do, when the brief should be submitted, whether we're in person or on Zoom now due to COVID. Every parameter of it. So it's beneficial to the litigants there, because there's certainty. We know exactly the rules of the game. Where, to your point, what you were alluding to, which is that in litigation, there's so much uncertainty. You have discovery, you have experts, you have lawyers, you have fees. I mean, it can get really, really unwieldy.
Well, and some of that information that goes through the process, once it's also out, it's out. Like if there's certain ways that you want to just resolve the situation without literally dragging everybody's laundry out and putting it on record, that is a way to basically do that. And if there is a sense of sensitivity on both parties, that's an added benefit. Okay, so
let me add one thing that you just raised. Another reason why it would be beneficial to do mediation beforehand is that there are a number of regulated industries in which you have to report judgments. So, financial advisors, lawyers, a lot of different industries are required under their regulatory regime to report judgments against them. And so if you can do a settlement where you can avoid getting a judgment against you, pay some money to the other side, and get your case resolved without even the potential of a judgment,
Right.
that has massive amounts of value.
Well, because otherwise it could affect your whole ability to practice in that industry. I mean,
Exactly.
depending on that industry.
You're literally putting your career at risk. So
Yeah.
that's another reason why, gosh, if there's an opportunity to settle it early and talk about it and try and resolve the various issues, I highly encourage everybody who's listening to at least explore it and think about it and talk to someone to see if that's a viable option.
And that someone should be that, you see that email, that website address right there on the screen? That's the first person you call. And what's the number, Brendan? Give him the number.
It's 714-450-6830.
And they asked for this gentleman right here.
Brendan.
Yeah.
So
and tell him Raad sent you. No, don't tell him Raad sent you.
Yeah, tell him Raad sent you.
Listen, okay, so let's switch gears for a minute here,
Sure.
just only to bring it kind of current, right? You and I were talking about how we are in a quagmire to begin with. We have cases backed up in court. We have court that is basically out. Are the courts back in operation, by the way?
Somewhat. Most of the hearings have been either by Zoom, or not Zoom, but by a telephonic. Some courts have allowed some in person, but they are open and resolving things, but in-person stuff has been severely restricted.
I heard some of the stuff was delayed to 2021.
Yes.
Yeah.
No, you're right. So we had a trial that was supposed to be set for August for this month, and it got kicked to April of next year. So
yeah. So that's what you're kind of looking at. But leaving that aside, okay, at this point, if you've been listening to Brendan on this, you should know that should be your first call. You should basically try to avoid the litigation, the going to court, try to basically resolve it through mediation, because it's going to come with a bunch of benefits that are meaningful benefits for you, especially if your industry is regulated with certain things like disclosures and the fact that you have lost or judgment is against you or whatever. But let's talk about what's going on with COVID and how the impact of this for people are still sort of in a stunned state. They're still sort of in a, we're in combat. I'm post-traumatic stress disorder right now. I'm barely trying to hold it on. The kids are driving me crazy. School is going to be, oh my God, I can't send it to school still. So I'm now really strained, right?
Yes.
You're not thinking straight. And so if you own a business, if you're out there basically interacting with other people, there's certain things that are happening that are likely to become almost like a trend when it comes to litigation, right?
Absolutely.
So let's talk a little bit of what you've been seeing and what you think is coming around the corner too.
Sure. So I'll give you one that is happening and 4 that I think will be happening. The one that has been exploding most recently due to COVID has been business interruption insurance claims. A number of attorneys throughout Southern California who are primarily contingency-based lawyers are taking these cases in order to sue insurance companies based on the failure to provide business interruption insurance. That is exploding, and that I see as a trend for the next, my goodness, 24 months at least.
And why are the insurance companies not providing that? I mean, I'm assuming you have a policy for that, right? Otherwise, you're fine.
Well, yes, because there are various issues, and insurance companies, well, without getting too political, the insurance companies often like to take an interpretation of contracts that absolves them of liability, and that's, I understand that, but the bottom line is that business interruption insurance is here. It's a hot topic. It's going to be a hotter topic going forward. But here are 3 or 4 more issues that are going to come up in the future.
Sure.
One, workers' compensation claims for people who get COVID while on the job. That's going to be exploding over the next few months.
So what do you say to somebody, which I've had some attorneys say to me, yeah, but you know what, that's causation and it's very difficult to prove. What do you say to that?
What I say is that even if the case you think is garbage, you're going to have to spend tens of thousands of dollars defending that allegedly garbage claim. And so it behooves you to spend a fraction of that to see if there's a way for you to come to a resolution with your employee pre-lawsuit.
So please, business owners, listen exactly to what was just shared,
right?
Because regardless of whether you personally believe on whatever ideological basis or business savviness or whatever you're being told by other people, it doesn't matter if it's garbage.
Right.
It still will go through the process to be cleared, and the process to be cleared is going to be expensive. So definitely, good, very, very good advice there.
And then, thank you. The second part of it is going to be labor and employment. I think cases are going to, namely failure to accommodate. You know, we've seen some cases. It's going to continue the failure to provide adequate PPE to people who work in your place. Now, for certain people where it's obvious, you know, if it's a hospital or some kind of frontline thing, that's one thing. But, you know, people have varying levels of sensitivity, and if they're in an essential business and they have to work there to adequately provide the level of PPE that they feel safe with, it, whether they are older or they have underlying, you know, comorbidities or what have you, that's going to be a huge issue.
Well,
And
Brandon,
then,
I'm sorry, correct me if I'm wrong, but, and I'm not sure how much of this is really kind of applicable, but I thought I saw in some of the guidelines that were provided by the state when it came to PPE, and it might have not even been the state, it might have even been CDC or maybe some other entity, but there were discussions about not only do you have to provide the sanitation stations, for example, for your employees, right? You also have to provide them the time between tasks to actually sanitize. And the reason I bring this up is because it was multiple times, and most businesses until before COVID, the only thing that you were kind of needing to provide, and I'm missing a whole bunch of stuff, but was like provide them a break. Like they need a 15-minute break, right? They got 15-minute breaks for how many ever hours that they were working. Right. And they had to take it, and they had the lunch break, and they had to take it, right? I mean, I've been at firms where basically HR would come over and say, "You're not supposed to be sitting at your desk. You're supposed to be go away," and you know, because we are now liable, right? So, with that being said, okay, these companies that barely provided breaks for their employees now have to provide not only sanitation stations, but you also have to provide the time for them to do this, right? And you have to provide the training for them to know how to do this and when to do this. All the while you're providing an environment that's experiential for your clients to come in, or whether it's pick up or maybe, you know, 50% accommodations if you're a restaurant, whatever. So that's also coming into play, right? With what you're talking about.
Absolutely. So before COVID, the corollary or the closest analog I could think of is there were these cases called like Don and Duff cases, which means that if you were forced to wear a uniform, there were a bunch of cases as to whether or not you got paid for the time it took you to get out of your regular clothes into your uniform, and then out of your uniform and into your regular clothes.
Right.
And so those were called Don and Duff cases, and the courts, you know, have resolved those depending on the jurisdiction and what have you. But I see that as a very similar issue. You know, when someone has to then clean their station or do this or get into their PPE or out of their PPE, how does that interplay work? And quite frankly, this is all so new that I don't know the answer, and the courts are going to have to figure this out.
As usual, it's going to be cleared by case law, right?
There's going to be a heck of a lot of litigation about this in order to figure out what the obligations are for various people.
What about exposure to how about businesses that may be doing PPEs and they're doing just fine, but then they are also now experiencing people coming in and saying, I'll just use this as an example, you can't force me to wear a mask. I deserve access. There's a whole bunch of people out there basically passing out cards that have no rights or basis. They're claiming some ADA disability, you know, just like, you know, there's a whole bunch of people selling this stuff to people to carry around just to basically be able to somehow justify that they don't have to wear a mask coming into a business. So the business is liable. So they have to not only, I mean, like announce and print the stuff and post it, right? But also have to basically then now, because they probably, depending on their jurisdiction, whether they have the support or not for enforcement, that's from a, you know, some kind of enforcement agency or police department, they in some cases are having to enforce this themselves. So that's going to cause conflict, right?
Absolutely. So the standard typically is for your employees is reasonable accommodation. And so, you know, if they're wearing PPE and people are coming in and and we've all seen the videos online of trying to storm into a grocery store or what have you, you know, courts are going to have to, or juries or courts are going to have to determine whether or not the actions that management took were reasonable under the circumstances to prevent, you know, they're not absolutely liable for their employees. That would be a standard that doesn't work. It would be untenable. But, you know, whether or not employers took sufficient precautions in order to ensure the safety of their employees is something that's going to be litigated heavily. And I suspect it's going to be on a very much case-by-case basis.
Well, and it probably requires training from the employer to the employees of how to handle those situations. We've all seen good situations or situations of this nature handled well, some that have not.
Right.
The person that's coming in thinking that, if you don't allow me access, now I'm going to basically sue you.
Right.
That's not a guarantee that you have grounds on this necessarily. The businesses are not necessarily liable, but I mean, again, there's so much uncertainty here. To your point a minute ago, there's so much uncertainty and lack of knowing exactly where this quicksand and shifting sands are.
Sure.
That the only way it's going to be resolved is over time coming out of this.
Right.
People, I mean, your profession is going to be pretty darn busy coming out of this.
Yes, we are. We're going to be very busy. And this is more of probably a more political than a legal issue. But, one of the big issues is who enforces this stuff, So, the governor or the state or the county or whatever the jurisdiction issues some kind of mandate, let's say for masks or what have you. And then the question becomes, if some person just decides, I don't care, I'm going to place X and I'm not going to wear a mask, where's the enforcement mechanism? Are you really going to have the manager at Gelson's be the enforcer, or are you going to have some kind of other enforcement mechanism? And then what are the ramifications of that?
Well, and if that business now has to enforce,
right,
that business basically, let's say, gets compromised or gets, has damages now, or heaven forbid, injury or loss of life because of having now been put in a place where they have to enforce. The state is saying these are the guidelines. These are mandatory. The local agencies basically are saying, well, we have a difference of opinion. I don't care. And then the enforcement basically is lukewarm at best or non-existent. And so that business, in order to basically, for two reasons, and I keep telling this to people, they're now subject to mandates by the state. They're basically having to decide which is more important. The majority of people that want to have a safe place and they have to provide visually that this is a safe place for people to come and spend their money, or basically side with, you have a freedom to do whatever the heck you want, right? They have to probably be conservative in how they basically approach this. And they will probably say, well, we're going to now have to enforce these guidelines ourselves. Right. But in doing so, they now experience some kind of injury or some kind of loss, right?
Absolutely. Absolutely. What you have described is a quintessential damned if you do, damned if you don't.
So that's the lack of enforcement by the enforcement agency that should be enforcing. Now put that enforcement agency and the local jurisdictions potentially as liable to that business.
I don't know is the correct answer. I would suspect not, just because local enforcement agencies have a number of immunities that make it very, very difficult to sue municipalities, states, counties, etc. So I would imagine that it probably wouldn't be able to do that. But that's the reason I said that this, I think, is more of a political question than a legal question. But there are real legal ramifications for that, right? To your point, if you
and political was. I mean, we're talking about right. So there will be a cost.
No question.
Right.
I don't know what the answer is to your question, but your point is valid, which is that there will be definitely a cost to that.
Well, and these businesses, if they have to enforce, I mean, I would not put it beyond this becoming a reality for us. Is if that business is caught in the sort of in the middle, like they got to basically enforce what they're being told they need to provide.
Right.
Their customers that want that safe environment, for example, is saying, yes, we definitely need PPE and you definitely need to enforce. Otherwise, if we don't feel safe, we're telling everybody this is not a safe place. Now you're losing business.
Absolutely.
You got 40 million people. I've been saying this on the shows. You got 40 million people out of work. Your discretionary spending reservoirs are now at 50% or whatever, God knows how much. You're competing harder to stay in business. You're operating at 50% capacity. You really cannot make a misstep of any nature. You may very well be basically now hiring guards to enforce the policy.
Right.
Which opens up a whole other can of worms.
Correct. No, the broader point is, and which I agree with you wholeheartedly, is that COVID has created a just onslaught of legal issues that we don't know the answers to, and will result in a tremendous amount of litigation on a go-forward basis. But there's one other issue that I want to make sure we hit in terms of cases that come out, and that is just contracts in general. Businesses have been, as you know, and as we all know, have been getting just crushed by COVID. Yeah. And so the ability for people to honor their contractual obligations has been diminished substantially and sometimes even erased.
Right.
And so one of the things most contracts have what's called either an act of God clause or a force majeure
Force
clause.
majeure, yeah.
Right. And so that, they say, and then determining whether or not COVID falls under an act of God or force majeure is something that's going to have to be
You happen
litigated.
to have somebody in your firm that actually speaks to that quite a bit, don't you?
I do.
Our good friend Lee Goldberg.
Yes, Lee is a transactional lawyer, and he's an excellent person, and he is very well equipped to handle those types of issues in negotiating force majeure.
But I'm sorry, I interrupted you because I just wanted to take that opportunity, since I was looking at the logo, I put the logo up behind you, that you guys also provide other things that are actually, in my opinion, super critical right now. The
Yes.
force majeure one being one, the AB5, which is not going away, it seems,
Correct.
is the other. And
Yeah.
so you guys have that under one roof. You have the ability and specialty to do that.
Correct. So in terms of our legal services, what we try to provide a full suite of services to the business community. So whether that be advisory, transactional, litigation, mediation, what have you, whatever a business needs in order to satisfy their legal needs, we attempt to provide.
So let's talk about that, because I mean, Lee has been on the show and we talked a little bit about the AB5 more so. I don't know. Force majeure, I don't know that we've really tackled it quite a bit, but please finish off your thought, because I think that is a super critical thing right now, both for people that are in dispute, but also, in terms of real estate impact, like between the property owner and the leaseholder.
Right. Now, I'll tell you a very specific example is we have a number of clients that are restaurants and bars, and they have been obviously getting destroyed. I mean, during the stay at home, some had little takeouts and here and there, but
if you're a bar, you're in, like, I don't even know how you're still around.
Trouble right now. And so, you have a lease with your landlord, which typically involves, your base rent plus some percentage of your sales that you contractually obligated yourself to do for oftentimes 5-10 years or more.
Right.
And, we're in a situation now where if you're running a bar and you have no customers, you have no income and no revenue, how on earth are you supposed to be able to honor your contractual obligations to your landlord under those circumstances? And to a lesser extent, even restaurants where, you have maybe a patio here and there, but 80% of your revenue is derived from the people inside. So now you are paying rent with the assumption that you were making 100% of your anticipated revenue. Now you're making 20% of your anticipated revenue. Right. Maybe you have reserves and you can do, but that's not sustainable in the long run.
Well, no, and at the beginning of COVID, some of the landlords, there was residential, commercial, but I was kind of looking at commercial too, because I do a lot of designs on restaurants, day spas, wellness centers that are basically lease locations, right? They're TIs. Right. So I was watching it, and a lot of the landlords actually stepped up to the plate, and whether it's motivated by the fact that if they actually were going to play hardball, they're going to walk away, they're going to look at a lot of empty property, or that they were actually, their heart was in the right place for competition, but whichever it was, a lot of them actually like deferred rent and did some of that stuff. But again, as this becomes no longer a bump in the road over a weekend or 10 days, and it becomes 6 months and a year, if you're a landlord, you can't afford to basically be giving away lease space for free.
Right.
Especially in an economy where commercial real estate is being hammered anyway because of, big boxes. Lord & Taylor today basically declared bankruptcy, right? Men's Warehouse is basically in chapter 11, sorry. It's really, this is real, right? This is really real for people.
And look, I don't profess to have the answers or any kind of thing. I'm just pointing out that the complexity and the magnitude of the problem is you have individuals who don't have a lot of money, who therefore don't go to small businesses, who therefore can't pay their landlord, who therefore can't pay their banks. And it becomes
it's dominoes. It totally does.
And it's untenable from soup to nuts. It just is.
Well, and so here's an interesting thing, because I didn't even really connect this with mediation per se, but there was a case, and because I've been watching this, right? And a friend of mine from Asia that basically their company basically manages something like 45 spas at either hotel properties or day spas, and he was telling me when this first started, I was talking to him, and he said, we just made $100 or $200 out of 45 spa locations, right? That day. That was it, right? So they were, and he was talking about force majeure, and he brought it up, and I'm like, which is basically, I don't know, I'm not legal, but it's like basically act of God clause. Like something happens that's out of your control, and it kind of gives you an out or whatever. So, so with that being said, I've been watching it, and then this thing comes on my radar, which was a case out of Illinois, where this restaurant, I think it wasn't a landlord, were in dispute about what rent was owed, and and when, how much of it or whatever. And the restaurant, I think, was saying, no, I don't owe you rent because I wasn't able to use my business was shut down. And the landlord was like, no, you owe me all the rent. Anyway, it turned out, it was interesting because I think the court basically ended up doing some sort of mediation, whether it was through, jury decision or whatever. They literally looked at the floor plan. And as a designer, I found this very fascinating. They looked at the floor plan. They realized that the kitchen component of the restaurant lease space was something like 20% of the overall square footage. 80% was the seating and dining component. And they basically said, restaurant, you've been doing pickup and delivery and therefore using your kitchen, but you have not been able to use your seating. So therefore you owe 20% of your rent to the landlord. And I don't know that the landlord really was happy to hear, or 25%, that 75% of the rent is now gone.
Right.
And how much, even, I mean, if that's a precedent, if that's been set as a precedent, as a landlord,
sure,
you are now looking at potentially everybody saying, you have to honor my lease, but here's what it's going to be until otherwise I'm allowed to open.
Right. But, it's funny that you tied that into mediation, because that's a perfect example of why mediation is superior, right? So while the landlord may be unhappy that the landlord's only getting 25%, right? Yeah. If a jury had found force majeure and you're obligated to you're out, then you get zero. So, 25%, while not 100, is better than zero. And so by using mediation, you can craft the types of solutions that you ordinarily wouldn't be able to go, because I don't know this case per se, so I don't want to say that I'm speaking to it directly, but
right.
Force majeure clause, you have to show whether or not you breached the contract, and whether or not there was a valid reason for your non-performance. And so the jury's either going to say yay or nay. And so if you put it in the hands of a jury, if the jury says yay, that's bad for the tenant, because now they're going to have to pay 100% of the rent
right.
on $0. Or if you're the landlord and they say nay, then the flip side of it. So
you're already in your industry as a landlord. You're already in an industry that's got a lot of vacancies. I mean, I tell people I've lived in South County in San Clemente since 1987, and so my commuting used to be, before the 73, used to be PCH.
Right.
I have been watching even before COVID. I have never seen this many vacant spots on PCH. It used to be that somebody with some stupid money, with some stupid venture, would come in there, and that landlord will lease it, and 6 months later or a year later, they would lease it again. And it was just like, basically, there was never a problem. You never found spaces. Now there's like, you could drive by, and before COVID, I would count a dozen spaces between here and Newport Beach that were vacant. So commercial real estate was being hammered. It's not getting any better because of the online sales and all this stuff that was happening, right? Ironically, I saw an article today or yesterday about how basically the online sales for stuff like, above ground swimming pools and backyard stuff, because people are sequestered. So they're basically trying to, get their kids out of the house to do something.
Right.
That the demand is so high that the suppliers are not able to provide, right? Meanwhile, commercial real estate is shutting down all over the place.
Right.
You're a landlord that holds, sorry, go ahead.
I have places, I've had the exact same experience in places that were Irvine company. I live in Irvine. So a lot of the places are Irvine company. And you see these really high quality commercial spaces with no anchor tenant, with huge spots that were gone. I mean, you see a lot of for lease signs everywhere.
And everybody last year, I think, as things were doing okay, but they were kind of plateaued, they basically started to increase capacity. I mean, that Spectrum got like expanded capacity. A bunch of people were putting money into older properties to uplift them so they could compete, right? A lot of the spaces that are on Jamboree that opened up for like WeWork style places, right? It's a horrible time for this. So again, if you go down traditional path, is I guess what I'm trying to get to. If you go down traditional path of resolving issues through litigation, you're probably looking at not only the fact that you're hurting now, but the fact that you're now going to carry a higher cost. And so mediation may be a thing that you should consider. What have you been advising, since you guys do a lot of restaurant stuff, just because I have certain people that in my wheelhouse that are going to listen to this, that are specifically, what have you guys been advising your clients? I mean, if it's okay to ask.
Of course it is. It's really dependent on the landlord, is what we found. And it's kind of frustrating because some of them have been really eager to work with their tenants and try and make things happen because they recognize the
we're all in this together kind of thing.
This together. Let me do a broader point, and then I will answer your question. Like it's not hyperbole to say that there has been a tectonic shift in our relationship to each other, to the world, to everything as a result of COVID. And so,
and we're not going back. I mean,
no, I said that to my law partner Chris today. I said that we are never going back to the way the world was in February.
No,
in my opinion.
Yeah.
So we have to reevaluate our relationship with everything, with office space, with how we communicate, with how we interact, with how we litigate cases, with every aspect of our life is up for scrutiny and up for reevaluation. And so I think the people who think that we are just going to, eventually this will fade out and we're going to go back to February of 2020, I think are very, frankly, misguided. I think the more important thing is to see and to be forward looking instead of rearward looking as to how we adapt and modify our ability and how we handle business and every aspect of our life in order to adapt to this, I hate the tired phrase, but new normal. But to your point, some landlords have been very good about doing that. Some have been really stringent and just saying basically like, well, you got to pay up and that's it. And unfortunately, what that's going to do is result in litigation, which if you thought it was bad now that you're not making revenue, imagine having to pay a lawyer hundreds of dollars an hour in order to litigate this case for a dispute that will in all likelihood not be resolved for 2 years. So if you file a lawsuit today, easily. So if you file a lawsuit today, it's August of 2020, you are not going to get a resolution at the earliest until August of 2022.
Yeah.
And so how as a business can you say, we'll just have this, floating in the ether unresolved for 2 years? It's not tenable.
Get ready to write checks. Get ready to write checks.
And you're going to write substantial checks and it's going to be very, very expensive. I mean, we get a lot of cases where people are arguing over, $100,000, right? Where someone will call and say, I believe I was not robbed, but defrauded out of $100,000. Now, no question, $100,000 is a lot of money, and that's a serious issue. But given the rate structure and the expense of litigation, it's not financially viable to file a lawsuit over something that's $100,000, because if you spend $120,000 in legal fees to recover
$20,000,
that's not a very good investment. Right. So that's one of the real problems with litigation, is that it becomes cost prohibitive very quickly, and at a very high threshold, it becomes cost prohibitive. Even some $200,000, $300,000 cases, depending on the nature of the case, can sometimes be not financially viable. And so mediation provides an alternative where, okay, you're not going to spend a ton of money, you're not going to spend a ton of money. We come together, we come to some kind of agreement, and we reach common ground. And now you both get to live your life and close this chapter and move forward and continue your business.
Ladies and gentlemen, Brendan Ford.
Thank you very much, Rod, for having me. I appreciate it.
I appreciate you being on, my friend. I really do. This is a topic that actually will be continuing to evolve. So I have a feeling you and I will be talking again, because I think what you shared today is unbelievably valuable for people, and it has a direct impact on not only their livelihood, but their peace of mind, their sanity, their ability to perform in other aspects of their life. Because if you are a business owner right now, you should be like absorbing this stuff as much as you can. I mean, the landlord, same thing. Over time, you might be dragging your feet or digging in right now, but how long can you dig in before it really starts to cost you? I mean,
exactly right.
Mediation seems to be exactly how you just phrased it, Brendan. You get it sorted out, you do it with the least cost impact, you walk away, and we talked about at the beginning, with your values maybe being met more so than the dollar amount in your checkbook. Right. You can move on. Because that's something, if you're holding on to going back to an old normal, just in general on this, you're not going back to the old normal. There's no going back to this. The benefits of doing certain things with technology, like stuff like we're doing right now, will never cause me to do it again. I was doing my show out of a studio every week, one time. I'm able to interview 10-folds the number of people from a house. And I told you were my first guest here with this second location for a studio, right? We're not going back to doing the same thing again, the same way we were doing it, because there are benefits. Mediation. Why would we do mediation after we're out of COVID? Because there's a benefit that has now been highlighted by COVID. It's been amplified by COVID. We will never basically abandon that again.
Right. In fact, to your point, there are now Zoom mediations where people don't have to travel. It used to be you'd have to fly to a mediation if it was out of town or what have you. Now you can do a Zoom mediation where the mediator's there. You have both parties. No one even has to leave their house. So I agree. That reminds me of that book, Who Moved My Cheese?
Who moved my cheese?
Exactly. And that's it.
You are definitely aging, both you and myself, with some of the book references that you used today, but it's true. I mean, hey, look, you guys just got some reading, required reading given to you by Professor Ford here, right?
There you go.
Who Moved My Cheese?
Getting to Yes by Roger Fisher and William Ury, and Who Moved My Cheese by Spencer Johnson.
I look forward to having you on again, my friend, and we really need to talk about that thing I talked to you about before, because if there's anything that proves that we should be doing that, and I'm not giving it away right now, is what we just experienced. Because,
perfect.
Right? Thanks everybody for joining us for another.
My friend.
Sorry?
I look forward to continuing the conversation, my friend.
Always a pleasure, Brendan.
Thank you
for being with me. Everybody, thanks for joining us for another episode of the Raad Life. We'll be back again. It's always content you can count on.